All right, so as Julie said, I'm Judge Peter McKittrick. I've been a bankruptcy judge for about 5 years. Before that, I was a Chapter 7 bankruptcy trustee, and we'll learn more about what that is, as well as a practicing lawyer in the bankruptcy area since 1986. So I've been doing this for a few years. So I want to first tell you kind of how the class is formatted. I'm going to give you some general comments and general thoughts about bankruptcy. I'm not going to talk specifically about, obviously, any of your cases because I don't know anything about your situations. I will do my best to answer your questions, but as Julie said, we're going to do it a little differently tonight, and if you could wait till the end, I'll try and leave about 10 minutes or so for questions, and I'm happy to answer any that I can, understanding I can't give legal advice, but generally the questions tend to be of a general nature and I can answer a lot of them. So don't be afraid to ask any questions you have. The other thing I want to say is I typically don't take a break. This takes about 40-45 minutes. I totally understand if you need to get up and use the facilities or just walk around, feel free to do so. I won't be offended. I won't take it personally. So, and hopefully the class will be informative for you. So the first thing is I want to give you a general overview about bankruptcy. Bankruptcy's a privilege. It's rooted in our Constitution. It's something that Congress and our founding fathers thought was important to have to facilitate our economy and be able to give people and businesses a fresh start if they get into difficulty. It's a powerful tool, and it should be used at the right time in the right circumstances. Your right to file bankruptcy and to get a discharge occurs once every 8 years. So one of the things that you're going to hear tonight that's a bit of a recurring theme is that you want to use your time wisely. You get a ticket in, you want to use that at the right time. And we'll talk about what that means in a little bit. Along with that powerful tool comes obligations. Are you coming on in? Okay. Comes obligations. So those obligations are you need to cooperate with your trustee. And we'll talk about what that means. If you have a lawyer, you need to obviously cooperate with your lawyer and provide timely information that they request. You have to follow the rules of the court. Otherwise, you may see me and you don't want to do that. And there's lots of benefits as well. Two primary benefits you get out of bankruptcy is you get an immediate stop to collection activity. We call that the automatic stay, and we'll talk about more about what that means in a minute. And at the end of your bankruptcy, you get a discharge, which means generally that your debts will no longer be owed and you'll be forgiven of the debts that you owed going into your bankruptcy. Assuming you do everything right, those two benefits will inure to your benefit as long as you do your side of the table, which is to cooperate, fully disclose your assets, and go through the system based on the rules. All right, so there are three general types of bankruptcy that we often hear about. The first type that we're not going to talk about more than what I'm going to say is Chapter 11. Chapter 11 is typically for businesses. It's for the Sears and the Toys R Us and the local businesses that have difficulty paying their debts and they need to reorganize and restructure. Although it is possible for individuals to file Chapter 11, it's not very often, and obviously it's not something we're going to really spend any time on tonight because it's not really germane to your situations. The second type of bankruptcy is a Chapter 13 bankruptcy. And a Chapter 13 bankruptcy is a bankruptcy where you pay your debts over time to the extent you can based upon the amount of income you have. Okay? People file Chapter 13 if they own a home and they're trying to protect the equity in their home, or if they owe taxes and they want to pay the taxes over a 3 to 5 year period. Can you hold your question? Write it down or think about it so we be sure we get it. So the clinic volunteers that are going to meet with you, some of you at least tonight, that volunteer their time, we don't do Chapter 13 bankruptcies. If your lawyer thinks or you think you need a Chapter 13, those can be paid. Those are typically somewhat complicated and involve more legal fees, but the legal fees can be paid as you go. So just because you don't have a down payment to hire a lawyer for a Chapter 13 doesn't mean you can't file. but it's beyond the scope of what we can do with volunteer lawyers. But if for some reason you may be a candidate for a Chapter 13, your lawyer can assist you in that process. So we're really here to talk about Chapter 7 bankruptcy. And Chapter 7 bankruptcy is often called liquidation. It's a quick process, relatively speaking. You file your paperwork, you have a couple of obligations you have to do, and you're typically out within about 3 to 4 months after you started. And so it's a quick process, as opposed to Chapter 13, which takes 3 to 5 years to get through. So let's talk about how you start the process. Well, the first thing you have to do is you have to go to a credit counseling course. Okay, you have to get a certificate from an agency that will provide you with a course. Typically, it's done online. Julie's going to give us a list of agencies that do it. Is that what that is?
These are agencies that are listed on the U.S. Trustee's website.
Okay. So the fee for doing that is, it can be as low as $5, can be as much as $35 to $50, depending on what agency you choose. If you're represented by a lawyer, that lawyer will help you steer you to the right place that'll be the most economical. Now, it's possible to get that fee waived, and we're going to talk about that in just a minute. But regardless, you have to have the credit counseling course done before the court will accept your filing. There are certain exceptions to that if there's an emergency, but it's a very narrow exception, and it's easy to do. You can do it online, you can do it by phone. Oftentimes you can do it from your lawyer's office if you don't have access to a computer easily. There's lots of ways you can get that done. But just beware, you have to get it done before you actually file your bankruptcy. All right, the next thing you're going to have to do is you're going to have to fill out, or at least have your lawyer fill out a bunch of paperwork. And we call those generally your petition, which is what starts the case, your schedules, which is going to be a list of all of your assets and all of your liabilities, and your statement of financial affairs, which I'm going to refer to as your SOFA, Statement of Financial Affairs. Your schedules, as I said, are going to list all of your assets at least by category. You don't have to list every piece of furniture you have, but you have to at least list your assets by category. You're going to list all of if you have any real estate, you're going to list that. You're going to list your vehicles, all the various assets you may have. Now, one asset that often gets forgotten, or people just don't realize it's an asset because you can't touch it or feel it, is you may have claims against somebody. Let's say that you were in an automobile accident and it was the other driver's fault. You haven't filed the lawsuit. Your injuries are still being worked on. You still have a claim even though nothing's been filed with the court. Or you were fired by your employer and you think you were discriminated against and you have an employment discrimination claim that you think you can bring. Those are assets, just like your cars, just like your furniture, and those have to be listed. So think about that in terms of assets is a very broad term. All right, your statement of financial affairs, or your SOFA, is a series of narrative questions about your past income, about transfers that you've made, about gifts that you've made, about lawsuits that you've been a party to, all sorts of different questions, again, so that the bankruptcy court and your trustee have a full picture of all of your assets, all of your liabilities, and how you ended up in bankruptcy. Bankruptcy is a self-disclosing process. The court doesn't do any background investigation. The court doesn't pull credit reports. It's a self-reporting system. As I said, it's kind of the honor system, and in exchange for that, you have to be honest or there's bad consequences. All right, so we've talked about your paperwork. You're also going to have to do what's called a means test form. And the means test asks you to go back 6 months and tell us what your income is, whether it's from Social Security, wages, unemployment, whatever source. Average that income over the last 6 months, and then you tell us what your expenses are, and then that tells us what your net is each month. The reason they do that started in 2005, is that certain wage earners that make too much money or have too much leftover income have to file Chapter 13. They don't get the benefit of the quick Chapter 7 because they make too much money and they're required to pay their debts over some time. None of you are going to be in that position, I can guarantee it, where you're going to have to worry about that, but you still have to fill out the form. And to the extent you have a lawyer, your lawyer's going to help you do all this. They have software programs, you'll give them the raw data, they'll put it into their program, and all these documents are going to spit out like magic. All right, so let's talk about fee waivers. When you file your bankruptcy, there's a $335 fee to file your bankruptcy. That can be paid in installments over a 3-month period, and we'll extend that under certain circumstances. So in the worst, you're going to have to pay the fee over in terms of installments. But in 2005, Congress enacted a fee waiver program, which if you're within 100% of the federal poverty guidelines, 150%, did I say 100%? Anyways, 150% of the federal guidelines, you may qualify for a fee waiver. So there's a separate form that you fill out when you file your bankruptcy that says, I'm applying for a fee waiver. If the court grants your fee waiver, then these credit counseling agencies and we'll get to another course later, you also will be able to qualify under those same conditions for a waiver of your credit counseling fee and the other class you have to do at the end of your case. So that's a good option that you should take advantage of if you can. As a judge, I review those all the time. I do look at other factors. For example, if you're going to get a large tax refund, large meaning $1,500 or more, I may make you pay the filing fee. If you have other money in the bank, even if the court isn't going to take it, something substantial, meaning $1,500 or more, I may make you pay the fee. Because obviously the fees are what generate and pay for the system. They also pay for your bankruptcy trustee. Your trustee gets paid a fixed fee of $60 and they get paid out of the filing fee. So if the filing fee gets waived, they don't get their $60, which they understand is part of their job and it's no problem. But we just be sure that there's an inability to pay under all sources, including based on your income. But you do have to be within that 150% or we have no discretion. We can't waive the fee. And I can tell you 90+% of the cases where there's a lawyer that's volunteering their time, I'm going to waive the fee because obviously if you've been through this clinic, you've qualified, your assets have been well vetted, I'm likely to waive the fee. All right, let's talk about what happens once you file your bankruptcy. The automatic stay goes into effect. The automatic stay is what stops creditors from all collection activity. So letters, phone calls, emails, text messages, any type of collection activity, continuation of lawsuits, those have to stop. Sometimes they don't stop because there's a timing problem and they don't get the notice quickly. But sometimes they don't stop just because they either ignore it or they're ignorant of the law and decide they're going to try and pursue collection activity anyways. If that happens, be sure you contact your lawyer if you have a lawyer. If you don't have a lawyer, be sure you write them a letter or respond to their collection demand and say, I'm in bankruptcy, here's my case number, stop, or I'm going to sue you. And we get cases all the time filed in bankruptcy court where banks, other large companies, either by mistake or just by a breakdown of their systems, keep making demands, and we hold them accountable for that. We take this very seriously. You deserve the benefit of your bankruptcy, and if you don't get it, the creditor needs to be responsible for that. All right, there's certain types of debts or certain types of actions that are not subject to this automatic stay, and you might think intuitively, well, if I'm part of a criminal proceeding, that's not going to stop. If I'm part of a domestic relations proceeding for support or for custody, that's not going to stop. And so certain types of actions are going to continue, but most general debt collection type activities, foreclosures, repossessions, all those things have to stop. All right, let's talk about the next thing that happens, which is there's going to be a notice sent out to all your creditors that you filed bankruptcy. and you want to pay, and you'll get a copy of that, and you want to pay particular attention to that notice because it has a bunch of dates in it that are important. The most important of which is it's going to have a date for what's called your first meeting of creditors. It's also called a 341A meeting because it is provided for under Section 341 of the Bankruptcy Code. That meeting of creditors goes out to everybody you listed, and you should list everybody. You should list family members that may owe you money, creditors that you think maybe you've paid but they still show up on your credit report. If there's any question, list them. There's no harm in listing them. So this notice is going to go out to all your creditors, and it's going to say there's a meeting of creditors at X time on X date, and the creditors are all invited to attend. I can tell you before you freak out, almost never do creditors attend. If you owe money to Les Schwab for tires, they will be there. Other than that, when I was a trustee, I'd have a day full of these meetings where I'd have 48 in a day, and I'd have 0 creditors at all 48 meetings. So the credit card companies, the medical bills, the credit unions, they don't show up. Unless there's something very unusual about the case, they don't show up. But you have to show up. And the other person that's going to be there is your trustee. Every case, a trustee is appointed. They are supervised and selected by the U.S. Department of Justice through the U.S. Trustee's Office. Their job is to review every case they're assigned to. They'll review all of the schedules that you filed, your SOFA. They'll review all that paperwork, and they will conduct this meeting. They're going to put you in a room. You'll be in a room with many other people because they, depending on the trustee, they have anywhere from 5 to 7 every hour. And they're going to put you under oath, and they're going to ask you a series of questions. And for those of you that haven't, you should go to the court's website. And if you just Google Bankruptcy Court Oregon, it'll come up. And on our website, we actually have a reenactment of a first meeting of creditors, so you can see what it looks like. The other thing I'd suggest is if your meeting is at 9:30 in the morning, first of all, show up early because it's easy to get lost because it's not in a courthouse. Secondly, come early because you'll see the hearings that happened before yours, and you'll see the questions that are asked, and it'll help put you at ease. And I used to tell people all the time when they'd say, "Oh, I'm so nervous," I'd say, "Well, just answer my questions and tell the truth and everything goes fine." They normally take 3 to 4 minutes. They're very quick, 3 to 5 minutes maybe. It's a standard series of questions just to be sure that you've filled out your paperwork correctly, you've disclosed all of your assets, you've disclosed all of your creditors, you've disclosed all the things correctly in terms of things like gifts and transfers and things like that. It's basically the trustee's opportunity to do his or her due diligence. And it's not a Perry Mason moment. They're not trying to trick you. They're not trying to make you admit to something that you didn't do. It's just a function. That's how we, because it's a self-reporting system, that's how we make sure that the people who file bankruptcy have done a complete job of disclosing all of their financial affairs. So those meetings are held, the specific trustee you'll be appointed to has maybe 1 to 3 of these meetings a month. So plan ahead in terms of the fact you don't have flexibility to change that date or change that time. And I mean, unless there's an extreme situation like a hospitalization or a death in the family, of course those things we try and accommodate. But the fact that you have to work, we all understand that's part of life, but you just have to plan ahead, make sure you can get off work. If you're going to be gone out of town for a couple weeks, try and time the filing so that you don't end up out of town during that time period with plane tickets you can't get a refund on. And that meeting's it has to happen under the Bankruptcy Code no earlier than 30 days after you file and no later than, I believe it's 40 or 45 days after you file. So it's a narrow window. It's going to be within that 15 or 20 day time period. All right, so the next job you're going to have is when you get this notice and you know who your trustee is, you're going to have to send him or her documents. And there's 3 sets of documents you need to send them at least 7 days before your meeting. Number 1, you have to send them your last filed tax return, federal and state. So If you file in 2019, you're going to have to send them your 2018 tax return, federal and state. You're going to have to send them pay stubs or proof of your income. So if you have a job, you're going to have to send them the pay stub that covers the date you filed your bankruptcy. Not the date of your meeting, but the date you filed your bankruptcy. If you're on Social Security or pension or disability, send them whatever you have that shows your income from Social Security, disability, or from pension. So sometimes you get the question, well, what happens if I haven't filed my tax returns? Either because I don't have to file returns or I just haven't gotten around to it. The code requires you to send the last filed tax return that you filed. If that was a year ago, send them the 2017 one. If it was 2002, just tell the trustee, write the trustee a letter or an email saying, I haven't filed tax returns because I don't have to, or I haven't filed tax returns because I haven't, so I don't have any to send to you. But don't just stay silent. Explain why you're not sending it to them if you don't. The third thing, so number 1, tax returns. Number 2, pay stubs. Number 3 are bank statements, covering the date of filing and about 30 days back. If you still have access, or if you have access to online, you can just print your statement and showing your activity for the date of filing back 30 days. If you get paper statements, bring your paper statement with you, and I'd bring, or not bring it with you, send it to them. I'd send the one that you get for the month you file, plus the one for the previous month, just to be sure they have enough time period. Because again, they're doing their due diligence. They want to see if there's been any unusual activity in your bank account during the time leading up to your bankruptcy, and they want to confirm what your bank balance is. If you don't have a bank account, again, just send them a note saying, I don't have any bank accounts, and the trustee will be fine with that. All right, so you go to your meeting, it goes fine, you spend your 5 minutes there. The trustee is going to tell you that this is either A, an asset case, which he or she will not, I can pretty much guarantee it, or B, it's what's called a no asset case. A no asset case means the trustee does not think there's assets available to pay your creditors based on what you own. And I can virtually guarantee that all of you are going to be in a position, with one exception, I'll talk about it in a minute, where your cases will be no asset cases, because all the assets that you own, clothing, jewelry, cars, retirement plans, are all going to be exempt. And we're going to talk about what that means in a minute, but it means that the trustee and your creditors cannot reach those assets. So it's very likely after your 5-minute meeting, the trustee is going to say this is a no asset case, and then there's a 75-day period approximately between the end of your meeting and the time when you're going to get your discharge. Why is it 75 days? Well, just in case some creditor thinks that you've done something nefarious, they have 60 days from that meeting of creditors to object to the discharge of their debt. Meaning, for instance, if you've borrowed money on your credit card, or you've borrowed money on a personal loan from a bank or a credit union, and they think you didn't tell the truth about your income or about your financial circumstances, they can seek to have their debt taken out of the bankruptcy and have it survive because of the fact that you were not truthful with them. That doesn't happen very often. It does happen sometimes, very rarely, but they have that 60-day time period to speak up, or their right to make that claim is gone. So, as I said earlier, the process is you file, you go to your first meeting of creditors 30 to 45 days after you file, you wait your 75 days, which is 60 for any objections to the discharge, plus some time for the court to process your discharge order, and you get your discharge and your case closes and you're done. Okay? That happens in 90+% of the cases. All right, so I said there's something called exemptions, and I want to talk about what those are. Exemptions are what the law says generally you need as a minimum to get your fresh start. So even though you filed bankruptcy, you have the right to certain assets and certain things that you have access to in order to make sure you're not left with nothing, so you can truly start again and have a lifestyle. So exemptions are covered under one of two schemes. There's what we call federal exemptions, which are set forth in the bankruptcy code, or there's state exemptions, which are set forth in the Oregon revised statutes, federal or state. You have to choose one scheme or the other. You can't say, I like apples from this one and oranges from this one. It's got to be one or the other. And each scheme has certain benefits based on the type of assets that you have. I can tell you with almost certainty that you all are going to benefit more from the federal exemptions than you will from the state exemptions unless you own real estate. That's the one general exception. But again, you should talk to your lawyer about this or look further into it if you don't have a lawyer to pick which scheme works best for you. And the reason I say the federal exemptions probably work better is there's what we call the wild card exemption, which is you can apply that to anything in the federal scheme. So let's say you get a tax refund. As a trustee, I used to collect all sorts of tax refunds before federal exemptions were allowed. Under the federal exemptions, you have a $12,000 wild card. So if you have a tax refund, if you have money in the bank, if you have an extra car, if you have other things that would not otherwise be accepted out of the trustee's reach, you can accept up to $12,000 worth of just anything. The state exemptions don't have that. So that's why I say for most of you, many of you it may not matter, but for some of you the federal exemptions may be a better choice. But that's a very individualized decision. So I've referred to things that are exempt. Your clothing is going to be exempt. Of the literally 15,000 bankruptcies I handled as a trustee, I sold people's home furnishings once. Clothing is going to be exempt. A vehicle is going to be exempt as long as it's within a certain value. And again, you've got that big wild card to help you if you have a vehicle that's worth more than what the exemption is. All of your pension, all of your retirement, all of your Social Security. Now, one factor to think of is if you have multiple sources of income, and for instance, you have Social Security and you have your wages, as long as it's traceable to your bank account, money in the bank is exempt just like the source of it. So if you have Social Security and you can prove the money in your bank is Social Security money, that's exempt even though it's money in the bank as opposed to the right to this payment, if that makes sense. So one thing you may want to think about is being sure you can trace where stuff came from in your bank account. Did it come from Social Security? Did it come from disability? Did it come from your pension? As opposed to other income you may have that may not be exempt in and of itself. So money in retirement, 401k plans, fully exempt. Equity in real estate in your residence up to $40,000 under the state scheme, exempt. Proceeds of a personal injury claim. Hold your question, I'll get to you as soon as I'm done. Write it down or keep it in your mind. Anyways, basically virtually anything you folks are going to have is going to be exempt. Meaning that the trustee's not going to take it and sell it and pay your creditors. Now, the one exception to that may be that if you've transferred money to friends or relatives, that money can be recovered by your trustee. The theory being that when you're in financial trouble, you should not be able to transfer either through gift or through repayment of debt to people that are close to you. You can't prefer them. It's called a preference. So, and we're talking about money that's more than $600. So we're not talking about Christmas gifts. We're not talking about, you repaid your aunt $30 that, she lent you 2 months ago. We're talking about if you get your tax refund and you had borrowed money from a family member and you pay them $2,500, that money's recoverable. So you want to be sure that, and that period lasts at least 1 year, depending on the circumstances, that a trustee can reach back. So you want to be sure that you talk to your lawyer about any transfers that you've made to friends or family members so that you don't get a surprise by filing and then having your relative get a call from the trustee saying, sorry, I got to get that money back. So that's an important part of planning your bankruptcy. All right, so I've talked about the discharge and the fact that when you get your discharge about 75 days after your meeting of creditors, your debts are essentially going to be eliminated. But as you can imagine, there are exceptions to that. The first one is certain taxes are not dischargeable. And that's a topic in and of itself I could spend hours on. But the general rule is that if they're within 3 years of the date of assessment, you cannot discharge them. If they're older than 3 years, you may be able to discharge them. But there's all sorts of tricks about that. So if you have taxes you're concerned about that you owe federal or state, be sure and talk to your lawyer about it so that you can get good advice about whether you can discharge those taxes. A second one are things like child support and spousal support. As you can imagine, Congress has said we don't want people to be able to get out of those types of obligations by filing bankruptcy. Criminal restitution is another one. Property settlements in a Chapter 7 are not dischargeable to a former spouse. Student loans, we get that question a lot. What about student loans? Student loans are generally not dischargeable unless there's a lawsuit brought within the bankruptcy court to discharge them. And the general rule is that you have to prove that repaying your student loans would be an undue hardship. And undue hardship is defined as trying really hard for a long time, proving you'll never be able to do it, and your circumstances are basically hopeless in ever trying to repay your loans. It's a very high standard. Not one the bankruptcy judges like and not one that we set. It's basically part of the bankruptcy code, and again, I could probably give a big lecture about how I feel about the dischargeability of student loans, but that would be inappropriate, so I won't do that. But the bottom line is you have to do something by filing a lawsuit to get a discharge of your student loans. The volunteer lawyers that are going to help you do not do those types of cases. That's the bad news. The good news is we have a separate panel of volunteer lawyers that have agreed to take student loan cases pro bono if it's the right case. And so if you have that circumstance, either talk to legal aid or to your lawyer about getting set up with somebody who may be willing to take a case to try and discharge your student loans. All right, so I want to talk about reaffirmation agreements and vehicles. So one question we get a lot is, what happens if I have a car or furniture and I owe money on my car or my furniture? Do I have to give it back, or how do I deal with that? Well, the general rule is that the debt associated with your car loan can be discharged like any other debt, but if you don't pay it, they're going to take your car back. And a lot of people don't want that to happen. Now, if you decide that you want to surrender a vehicle that you finance because it's just too expensive, you are welcome to do that, okay? And they can't chase you for any balance that you would still owe because that debt's going to be discharged. But if you have a car that you want to keep and you want to keep paying on it, for instance, you borrowed money from a credit union and you want to stay in good standing with the credit union and you want to be sure that you keep your car, there's a process called a reaffirmation. And you have to sign an agreement with your creditor saying that you are going to agree to keep paying. And that has to be filed with the court, and all that has to happen before your discharge is entered. Otherwise, the debt is discharged and reaffirmation agreements are not valid. The other thing is, if you do that, not because you've been bad, but you may have to come see me, because under certain circumstances, the judges have to approve a reaffirmation agreement, because there are consequences. It's great you get to keep your car, and it's great you get to stay in good standing with your credit union if that's why you're reaffirming a debt, but there's risks. Because what happens? Well, most cars depreciate faster than you pay the loans on them, right? So you typically have a car that's worth $5,000 and you still owe $10,000. If you reaffirm the debt, you're taking that debt out of your bankruptcy, meaning you still owe it. So if you reaffirm and you can't make your payments in the future, you have to give the car back, you're still going to owe that money, that difference between the value of the car and the amount you owe. So there's risks to reaffirming. So Congress has said before we'll let reaffirmations go through in certain circumstances, the person has to come before the judge and the judge has to decide it's in your best interest to do that. So that's the one circumstance that you may actually see me. A huge percentage of Chapter 7 cases other than that, I never see. You see my signature on things because it gets auto-stamped, but you never actually come to court and see the bankruptcy judge other than for reaffirmations or unless there's a problem with your case, which typically there's not. All right, so last thing I want to cover before I'll take a few questions is, should you file? That's always a difficult question because, as I said earlier, you have a ticket in only once every 8 years and you want to use it wisely. So some of the things that I would look at is, number one, do you really have to file? Do you have assets that you're trying to protect from your creditors? If you're what we call judgment proof because creditors can't reach your assets anyways, maybe you don't have to file, even though you're getting calls and there's judgments. If you have no assets, if you live on Social Security, you don't have wages, you don't have outside income, you don't own real estate, have at it. There's nothing they can do. So that's one factor. Another factor is, well, but the phone calls and the letters, it's understandably extremely stressful. And the bankruptcy will stop all that. So that's a good reason to file. But that's the balancing act. Do you use your ticket today or do you wait? Or do you use your ticket now to get the relief that you want from your phone calls and the collection activity? An example, if you don't have health insurance or you're driving, which you should not be, without liability insurance for your car, what happens if you file bankruptcy and then 2 weeks later you get sick and you end up with large medical bills? The bankruptcy only covers what you owed as of the date you file your bankruptcy. It does not cover debts you incur after that date. That's a hard and fast date. So if if you think you may get medical insurance in the future but you don't have it now, maybe you wait until you have insurance so you know you're not going to have more debts. Now there are some things. There's a federal law called the Fair Debt Collection Practices Act, the FDCPA, that governs debt collection. And it provides that if a debt is held by a collection agency, you can write them a letter and you can tell them to stop contacting you and they have to stop contacting you. So to the extent you're getting letters, phone calls, emails, text messages from debt collectors, that can stop without the need to file bankruptcy. To the extent that those collection activities are happening with the original creditor, meaning the person you borrowed the money from or that you incurred the medical bill with, that's not the same rule. So that's not going to help you. But to the extent the debt has been assigned to a collection agency, a debt collector, you can write a letter and they have to stop contacting you. So that's an option you ought to speak to your attorney about, and that may assist you without having to file your bankruptcy. The last thing I would say is that again, just like in your bankruptcy, if you've written that letter and you keep getting calls, keep a log. Keep a log of all the activity that you're getting in terms of collection activity when you shouldn't. Same thing if you filed bankruptcy and you're getting calls from your creditors, keep a log of when they called, who called you, what time, from what phone number, because again, the bankruptcy court takes those things very seriously, and there's lawyers that will take those cases to sue those creditors that don't comply with the bankruptcy laws if they keep contacting you. All right, those are all my comments.